To quote Justice Sarmiento, it was a long and horrible nightmare when our people's rights, freedoms, and liberties were sacrificed at the altar of national security. In closing, Your Honors, we revised our Constitution on this very day to prevent horrors like this 34 years ago. If there were any case in the minds of the framers when they created expanded judicial review, this, this is that case. Someday, the political branches may yet undermine the judicial, may dim once again. But please, let it not be under this honorable court's watch. To Your Honors, we entrust the faith of our Constitution, the dignity of our judges, and the lives of generations of Filipinos.
Thank you very much, Congressman. Can I call on Atty Molo? Okay. Good afternoon, Atty Molo.
Good afternoon, Your
Yes.
Honor.
Yeah, Article 3, Section 6 of the Constitution permits the impairment of the right to travel in the interest of national security, public safety, or public health as may be provided by law. Isn't terrorism a national security or public safety matter that may be considered by Congress to restrict the right to travel?
Yes, Your Honor. Terrorism is a lawful subject that may be the subject of legislation to limit a constitutional right, but the limitation must still comply with what the Honorable Court has stated regarding the Bill of Rights.
All right. Under the third paragraph of Section 34 of the Anti-Terrorism Act, when an accused charged of terrorism has been granted bail because the evidence of guilt is not strong, may his freedom of movement still nonetheless be limited to within the municipality or city where he or she resides or where the case is pending.
Yes, Your Honor, and that is particularly odious in Section 34. Why? Because here, evidence of guilt is not strong, but upon mere application of the fiscal, the judge, the law says, the judge shall limit the movement of the individual. How can that happen if the evidence of guilt is not already strong? In fact, Your Honor, if we limit the movement of the individual, that reminds me of distero, which is actually a punishment under the revised penal code. So how can we have a law that allows an individual who, according to the prosecution, cannot be proven to have committed it because evidence of guilt is not strong, and yet the law allows the fiscal, upon mere application, to limit movement, and the law says the judge shall do so. That is why, Your Honor, we also raise it as part of the grounds that this law turns judges into rubber stamps because of the phraseology of the law. Therefore, it is diminishing the judiciary.
Now, cannot Congress, through law, pass special limitations on a bail grant in the interest of national security or public safety, considering that what is involved here is terrorism?
Yes, Your Honor, I can answer that question in two levels. Conceptually, yes, they can pass laws, but always in compliance with the Constitution. And second, never in a matter that concerns the procedure before the courts. And this concerns procedure before the courts. Your Honors, if I may, there will always be an existential threat facing every generation. Each generation, if we look at history in this country, all over the world, there will always be an existential threat. But the purpose, the very purpose of the Bill of Rights, according to Justice Jackson, as initiated here in this jurisdiction under Philippine Blooming Hills, the very purpose of a Bill of Rights is to remove certain subjects from the vicissitudes of political controversy. Our rights to speech, assembly, religion, association. These do not depend on any election. If Congress can, by mere legislation, change all of that, then what are the Bill of Rights for?
Okay, my last question is, wouldn't you consider these restrictions as a policy matter that should be left to the wisdom of the legislature?
Yes, Your Honor, I would respond to that in two levels. First, it sounds to me like a question of political question. The classic definition of political question is Baker v. Carr. And in Baker v. Carr, the primary requisites are there must be a constitutional commitment as found in constitutional text that the matter has been committed to another branch of government. For example, impeachment. It has been assigned to Congress. That does not apply here, especially with Section 29. The textual commitment is to judges, to the judiciary. Warrants must be determined personally by the judge. So the reverse actually applies. The second element, Your Honors, in Baker versus Carr is that there lacks any discoverable judicial standards to guide the honorable court to determine the controversy. We have judicial standards, Your Honor. They're the Bill of Rights and the entire body of jurisprudence enacting the Bill of Rights. These are judicial and they have already been discovered over the decades.
Okay, thank you very much, Atty. Molo. That would be all, Chief. Thank you.
Thank you, Your Honor.
Justice Marvick Leonen is the next interpellator. Now, as agreed upon with the other members of the court, we will adjourn at 5:30 today, no? And then we'll have a resetting probably next week.
Can I have Professor Molo again at the podium? Professor?
Yes, Your Honor.
Yes, there is always an existential threat to every generation, but you think that it might be irresponsible for us not to allow Congress to try to find the balance to address both the existential threat as well as protection to the rights that are enshrined in the Constitution.
Yes, Your Honor.
So in other words, we cannot assume that just because there is a law, that there is already a challenge to the Bill of Rights. Is that not correct?
Yes, Your Honor.
And it is also right for us as a body that has been constituted only as the judiciary to assume that the members of the House, the Senate, and even the President is very aware of all the provisions in the Constitution. Is that not correct?
Yes, Your Honor.
And therefore that they may have already seen, in fact, predicted that there will be at least one petition, perhaps they did not predict that it will be 37 and more, that will be filed in the Supreme Court whenever they try to address the perils of terrorism. Is that not correct?
Yes, Your Honor.
Yes.
We might.
And therefore, well, you quoted Justice Jackson. Is that a Filipino justice?
No, Your Honor, but
Yes.
his ponensya was already
Yes, but why should we
incorporated
listen
in
to
Philippine
Justice
Bill.
Jackson? It's the Philippine flag that flies over the Supreme Court. Because I noticed that you are fond of citing Jackson, Baker versus Carr, US versus Stevenson. These are not jurisprudence here. Is that not correct?
Your Honor, yes.
You might
are
have as
correct.
well cited South African jurisprudence or Indian jurisprudence. But as far as we are concerned, as I will show you later, we have had our own interpretation of actual case and the more recent one. Is that not correct?
Yes, Your Honor.
Yes, okay.
Yes.
So, in other words, the court has maintained a policy of deference simply because of the nature of the court itself. Is that not correct?
Yes, sir.
Yes. And, well, for example, there is this case of the AITA that was mentioned by, I think, Attorney Latif. But my question is related to your share of the oral arguments. Isn't that the actual case?
The ITAS, Your Honor?
Yes, the AITAs were charged with provisions of terrorism. Provisions that are found under Republica 111469, correct?
Yes, Your Honor.
Yes. Isn't that the actual case?
Yes, Your Honor.
Isn't that the perfect case that will delimit the actual challenge to clear provisions in the Constitution based upon clear facts? Because as far as we are concerned, for example, you mentioned that there was this post saying that some members of the UP community were communists that were captured or killed. Is that not correct?
Yes, Your Honor.
Yes, and in fact, one of the lawyers there, I know him, Rafael Aquino, came out and said, I am neither captured nor killed. I
Yes,
was
Your Honor.
never captured nor killed because here I am, right?
Yes, Your Honor.
Yes, and what happened to that?
I believe, Your Honor,
It was
Attorney Aquino
withdrawn,
is a
correct?
counsel here.
Yes,
Yes,
it was withdrawn, correct?
Yes,
It was
Your Honor.
withdrawn, yes. And the Secretary of National Defense apologized. Is that not correct?
Yes, Your Honor.
In fact, he fired, or I think he demoted or removed the J2.
Yes, Your Honor.
J2 is, I think, part of the Chief of Staff of the Armed Forces, and that is number 2.
Yes, Your
If
Honor.
I'm not, no, I think it's 2. Number 3, because 1 is, I think, operations, if I'm not mistaken. 2 is intelligence. And in fact, even a deputy of the spokesperson also took a leave because of that snafu. Is that not correct?
Yes, Your Honor.
And it is maybe not for this court to base its ruling on that set of facts, because that is not the case. It evolved and the government itself corrected its error. Is that not correct?
Yes, Your Honor.
Yes. And with respect to frozen assets, there is the case of rural missionaries. Is that not correct?
Yes, Your Honor.
As a matter of fact, I heard one of the counsels today say, I cannot state anything about that case because she is not the counsel to the case. Is that not correct?
Yes, Your Honor.
And we are to rule on a constitutionality of the provision of freezing of assets on the basis of facts, which are in another case and which can be pending with the Court of Appeals. Is that not correct?
I believe the RMPs are
You mentioned
consolidated with this
you
case.
mentioned rural missionaries, you mentioned Facebook posts, you mentioned red tagging. All of them can ripen to actual cases that can be filed either with this court, if they so wish, based on Gios versus Samar, however, with a warning, or with the lower courts. Is that not correct?
Yes, Your Honor.
Yes. So you are now asking this court to rule upon a law that is live, that has already, according to you, have had many consequences. Is that not correct?
Yes, Your Honor.
Yes. Now, so therefore, the concept, I think many of us have difficulty, although we understand the positions of many of the petitioners, we understand the fears. Personally, I truly understand the kinds of fears that you're undergoing, having undergone those fears myself when I was a public interest lawyer. I understand that. But with the hat now of a justice of this court and with this judiciary, I think it is correct for us to assume that we should be careful not to become a political department. Is that not correct?
Of course, Your Honor.
Not to substitute our political wisdom to the political wisdom of, let us say, those that have crafted this law and those that have advised the president, including the National Security Advisor, who I believe is in the room. Is he here? The National Security Advisor. We have allowed him to be present. Give advice to the president and perhaps even to some key leaders of Congress. Is that not correct?
Yes, Your Honor.
Yes. So only in an actual case where it can be clear, there can be a clear and convincing demonstration that there is repugnancy with the specific text in the Constitution, will there be an act by this court. Is that not correct?
Not necessarily, Your Honor. I beg to disagree. Of course, we do allow facial
So
challenges
Francisco
in this
versus
jurisdiction.
House of Representatives, when was this case promulgated?
Your Honor.
Francisco versus House of Representatives, when was this promulgated?
Your Honor, this I believe it's
2003.
the VIDA impeachment
2003,
case. Yes, Your Honor.
right? Southern Hemisphere, when was this promulgated?
After the 1987.
2010. Dicini, when was this promulgated?
As well, Your Honor.
2014. Imbong, when was this promulgated?
I failed to
2014.
recall the actual.
Did you ever mention Gio Samar? When was this promulgated?
I believe 2 years ago, Your Honor.
2018, right? And who was the ponente?
The amicus.
Amicus. And this court
Of course, when I was absent, I could have voted also for him to become amicus, but he's now amicus. Isn't that a signal? Perhaps it is, correct?
Yes,
so
sir.
now, Gios was 2018, right?
Yes, sir.
And none of you have mentioned the slew of cases that followed Gios. And I will show you there in the PowerPoint that there were cases like National Federation of Hog Racers. There was the case of Provincial Bus Operators Association. There. Falsis versus Civil Registrar General, where the Solicitor General won in that case on same-sex marriage. By the way, do you know the ponente of Falsis?
It was you, Your Honor.
Yes. And then Provincial Board Bus Operators. All of them, by the way, are unanimous decisions of this court. Let's look at the last case, Parconsong versus Lilia Parcon, where the court said, in terms of the extraordinary jurisdiction of the court, can we flash that quote? This is again, Article 8, Section 1 of the Constitution, which specifies that courts may act upon any grave of abuse of discretion by any governmental branch, does not license this court to issue advisory opinions. Apart from an actual case or controversy, this court must be satisfied that the reliefs prayed for require the resolution of a constitutional issue. But there is an exception, of course, in Parconsong. Are you aware of the exceptions? Again, this
Yes,
is
sir.
part of a unanimous decision of this court, correct?
Yes, sir.
Yes. So, therefore, it is clear that it again reiterated the case of Southern Hemisphere. Is that not correct?
Yes, Your Honor.
Yes, okay. In Southern Hemisphere, however, it is not that freedom of expression is alleged as having been violated. Not only that, there is an additional requirement, correct?
Yes, Your Honor.
That there must be a clear showing of overbreadth, right?
Yes, Your Honor.
And there's a difference between overbreadth and void for vagueness. Is that not correct?
Yes, Your Honor.
Yes. Can you make a differentiation?
Void for vagueness, Your Honor, offends the due process clause in the sense that two reasons. One, it deprives fair notice to the individual on what the criminal behavior is.
And as clearly stated in a ponencia, if I'm not mistaken, by Justice Ardelesa, void for vagueness, because it applies only for the due process clause, requires as applied. There must be actual facts, correct? So what we are talking about when we invoke the exception in Southern Hemisphere is overbreadth of a provision that will run afoul the freedom of expression clause. Is that not correct?
Yes, Your Honor.
But that was qualified. So Southern Hemisphere was way back in 2010, correct?
Yes, Your Honor.
And there is now this, again, unanimous decision of this court in Spark versus Quezon City, which you mentioned, right?
Yes, Your Honor.
And I think the ponente herself quoted a very clear statement in that provision. It is not that it appears void to the petitioner. It is not that it appears void to the petitioner, but there must be a clear and convincing showing that there cannot be any other interpretation except that it will infringe a certain right. Is that not correct?
Well, Your Honor, I would, with due respect to my former professor in constitutional law, disagree that facial challenges only follow that line. There are also facial challenges that have more recently been recognized.
Name one.
Your Honor, in I think because the formulation you are referring to is Salerno.
Loidan Nicolas.
Yes, Your Honor.
There were facts.
Yes, Your Honor.
They were excluded
2019. Yes,
from
Your
the campaign, correct?
Yes, Your Honor.
So there were facts,
Yes, Your Honor.
right? So now, do you have facts?
Yes, Your Honor.
What facts have been established by evidence?
The operative fact in a facial challenge, Your Honor, is the passage of the offending law against
I'm sorry,
the text of the
again?
Constitution, Your Honor.
Again, well, just today, in the case of Diraugo versus Martires, this court again reiterated that line, dismissing a petition outright on a challenge to Memorandum Order Number 1, very clearly stating that it cannot just be Southern Hemisphere, and then after that, Samar, then after that, Parconsong, then after that, all of those cases, including the case of Spark. You seem
Yes,
to
Your
have
Honor.
missed all that jurisprudence.
Well, Your Honor, of course, I would agree with you.
Of course,
Your
it's
Honor.
understandable because one of your petitioners is really the ponente
Yes,
of
Your Honor.
Southern Hemisphere, correct?
Yes, Your Honor.
But even her ponentia was very, very clear.
Yes, Your Honor.
And it was clarified further by other cases which evolved based on the history of this country and based on the jurisprudence of this court. Is that not right?
Yes, Your Honor.
Yes,
And
so-
if I may,
What are your facts?
yes, Your Honor. If
Do
I
you have
may,
facts?
yes, Your Honor.
What are the facts?
Your Honor, that Congress has in fact passed a law that violates the
So that's
Constitution.
not a fact.
Your Honor,
That's the passage of
unfortunately,
a law.
if we follow your line of thinking, then we would be
No, it's not
erasing
my
the
line.
distinction
It is not my
between
line.
as-applied challenges.
Excuse me, counsel. It is not my line.
I'm sorry.
I have shown you the genealogy of jurisprudence.
Yes, Your Honor.
Baka nga lumabas sa bar yan kung ano, di ba? Well, it's not a tip. But in any
Yes, Your
case,
Honor.
the point there is that line of jurisprudence.
Yes, Your Honor.
Yes. So how do you contend with that? Where the court clearly said it is not merely the passage of a law that entitles a person that will come out up here to annul that law, because otherwise it's an advisory opinion. We act as a third chamber of the legislature over and above the approval power of the president. When we act upon a law without the facts, precisely the judiciary was created in order to be able to look at evidence that generates facts which may have been overlooked by the legislature and the president when they passed the law, or to help clarify the text of the law. In the absence of those facts, it is up to the president when implementing the law to pass implementing rules to guide the execution of a particular law. But it seems to me that even implementing rules of the president, here, the ATC, because it clarifies concepts such as designation and delisting, because it clarifies concepts like inciting and advocacy, that you want that annulled even, disregarded. And you want us to focus on the law, and instead of giving liberality to the political departments to do what is right by the Constitution, you want us to exercise our power to jump the gun and simply say the law is unconstitutional.
Well, Your Honor, if I may answer the line of questioning of the Honorable Esteemed Justice.
But there is no question yet.
Oh, sorry.
Yes. Isn't that what you want to do?
Your Honor, we are invoking expanded judicial review. In 1987, when Justice Cecilia Munoz Palma delivered her closing remarks,
Again, with
the
due
last
respect
session
to, with
of
due
the
respect to
Constitutional
Cecilia Munoz Palma, when she made that speech for the Constitutional Convention, that was 1987, correct?
yes, Your Honor,
And how many years have passed since 1987?
34 years.
And there is a
this very
constitution that has to address everything that happens in our historical timeline from 1987 to 2021. Is that not correct?
Yes, Your Honor.
And now in 2021, it is this court that sits.
Yes, Your Honor.
So you want us to forget all the jurisprudence that has been evolved from 1987 to 2021 and simply disregard all of this advice to petitioners. Come to court only if you have the facts. If it is irrefutable, come to court only if you have a freedom of expression case when you want a facial challenge, but show to us clearly and convincingly that the political departments cannot interpret it in any other way except to chill and to violate the right of freedom of expression. Do we have that now?
Yes, you do, Your Honor. Yes, we do.
In spite of the implementing rules?
Yes, Your Honor.
For
Because,
instance,
for example, Your Honor, let's go into the subject of chilling of speech. The sword of Damocles, the damage under constitutional law is not because it falls, it's because it hangs. The passage of the law may not cause a direct harm, but the harm, for example,
Professor,
on the professors.
Professor, if I show to you a law passed in 1939, which is broader than the provisions here, but did not cause a chilling effect despite the broad provisions. Would you say the chilling effect must also be something that must be clearly and convincingly shown to us? For
Yes, Your
example,
Honor.
I show you the provision on inciting to sedition, 1939. 1939, inciting to sedition, clearly said, inciting.
Yes, Your Honor.
Okay. Where is it? Yon, inciting. Tends to. That's even a broader provision. That's 1939. Yet, Professor, what happened in 1986?
We had a revolution, Your Honor.
And the revolution consisted of people going to the streets in mass waves. Even 1983, 84, 85, then 2000 also happened. Then many other things happened despite of this provision on inciting to sedition.
Yes, Your Honor.
The provisions are a bit broad, correct?
Yes, Your Honor.
In
But
spite of it being in the statute books, it was not enough to chill the entire population that went to EDSA in 1986. Is that not correct?
yes, Your Honor.
Yes. Now, you are claiming that the provisions in section 4, 5, 6, 7, 8, and 9 chills.
Yes, Your Honor.
That is your best argument to invoke Southern Hemisphere, correct?
Yes, Your Honor.
Yes. What's the difference with this provision?
Well, if we look at the sedition, which is the predicate crime of inciting to sedition, Your Honor, we know what the prohibited conduct is.
Oh, really?
We are looking
Let
at
us look
people
at-
rising tumultuously.
Excuse me, Professor. Let us look at the article on sedition and see how dangerous it might be. To prevent the promulgation or execution of any law or the holding of popular election. To prevent the national government or any provincial or municipal government or any public officer thereof from freely exercising its or his function or prevent the correction of any administrative error. You know my prediction? If you were alive in 1939, you would have filed a petition with the court.
Yes, Your Honor. But I would also point to the first part. Which,
But you see what I am aiming at?
yes,
What
Your
I'm
Honor.
aiming at is, should there now be a sort of a limitation on what is meant by chill in terms of freedom of expression? Unless you want this court to be so powerful that in spite of some provisions in the Anti-Terrorism Act, where it tries to find a balance, regardless of how the wordings are. So for example, in section 4, subparagraph E, correct?
Yes, Your Honor.
There are provisions there which says where it will not apply, correct?
Yes, Your Honor.
And the provisions are also qualified. Is that not correct? Section E,
Yes, Your Honor.
right? So it says that the qualification in subparagraph E says that it will not apply. Next slide, please. Provided that terrorism as defined in this section shall not include advocacy, protest, dissent, stoppage of work, industrial or mass actions. My God, this is even better than the inciting to sedition provision. Don't you see, counsel?
Yes, Your Honor.
Because it carves out an exception. And the carved out exception there is advocacy, protest, dissent, stoppage of work, industrial or mass action, etc., are not included in acts of terrorism. Correct?
Yes, Your Honor.
Yes. So isn't this better?
Which actually makes it worse, Your Honor, because now you have the definition of terrorism directly covering civil and political rights, and all the prosecutor
No,
really
it's not
needs
part
to do
of definition.
is attach the last.
It says there, terrorism as defined in this section shall not include. Baka your copy did not have not.
Yes, Your Honor, but after that is except those which are not
Except
intended
which are intended
to
to
cause death or
death.
serious physical harm.
You mean to say that we should allow protest that causes death?
Well, Your Honor, that is part of our assertion, Your Honor, that actually is the first
excuse
law
me.
that includes.
So in our sovereign guarantees that the people shall be the sovereign, we allow some people to do advocacy that causes death.
Yes, Your Honor, Brandenburg versus Ohio, which is the line of questioning by
Yeah,
Justice
no,
Bernabe.
this one says advocacy. doesn't say incitement. Doon tayo sa incitement section 9. For here, it's only advocacy, right?
Yes, Your Honor.
You mean to say people can cause death?
No, Your Honor.
Does
It
that
simply
not
says
restrict
advocacy, but not cause.
John Stuart Mill on liberty?
Yes, Your
You
Honor.
can
but
only have the
advocacy-
liberties for so long as you do not harm another person, correct?
Yes, Your Honor.
That's embedded into a liberal society, correct?
Yes, Your Honor.
And even I would say even a socialist one, if I may be so blunt, correct?
Yes, Your Honor.
Yes. So you mean to say that any of these exercises that causes death cannot be prevented by government?
Your Honor, the provision turns on the phrase intended. It doesn't say causes death. There's a difference, I believe, in exercising one's rights for advocacy of imminent lawless action versus something that actually causes advocacy to cause it.
So counsel, by the way, maybe let's maintain eye contact because I'm the one talking to you. Okay?
Sorry, Your Honor, I was also
Because you
looking
were-
at the provision.
You were
of that.
always looking at other justices. Yes.
Sorry, Your Honor.
We're the ones
Yes, Your
talking. Yes. Okay. Now, intended to cause death. You mean to say government cannot prevent? They have to wait until there is somebody that dies.
Oh, definitely not. That is not our
So
proposition.
that is, I think, the purpose here. You can advocate, you can exercise your civil and political rights, you can do mass action, you can even strike, you can even do stoppage of work. But when your intent is clear that you are moving towards killing somebody, government should be able to step in, correct?
Yes, Your Honor.
Yes, so that can that be the interpretation of that provision?
It could be, Your Honor.
Yes.
It could not be, but then it devolves into vagueness because the second element of vagueness is that it leaves too much arbitrary discretion to the
Again,
enforcer.
I think we are confusing the concept of overbreadth in freedom of expression cases and void for vagueness. Void for vagueness, again, as you yourself agreed to, and you're a professor in constitutional
Yes,
law.
Your Honor.
Yes, preparing your students for the bar exam, right?
Yes, Your
Okay, now, void for vagueness means it must be applied, right?
Yes,
Now,
Your Honor.
again, let's apply the test in Spark. Is there no possible interpretation at all that has been taken by government to save that?
It is our position there is none, Your Honor.
So you
because
are
it
again
covers
saying
advocacy and civil
that
political
government
rights.
cannot step in to stop a kind of action where the intention is to cause death upon another.
It is, Your Honor.
So when groups of people are out there calling death to Leonen, as I come out, okay, death to Leonen, and you can see that they are about to kill me, government should not step in. That is not an act of terrorism, right?
It is punishable under a different crime, Your Honor.
Under,
A different crime, Your Honor. If someone is going to kill you, Your Honor.
yes, that one. It says intended to cause death.
Yes, Your Honor.
Yes,
but
like
if that would be the case, then we would
Attempted
slide.
murder, frustrated
Yes, Your
murder,
Honor.
attempted homicide, frustrated homicide. That can be the interpretation there, correct?
Your Honor, it punishes terrorism under a different law, and therefore,
You've
It's
seen the
like-
attacks on the Capitol in Washington, correct?
yes, Your Honor.
Yes. That was a throng of people. And they were, you do not know which ones of them would want to seriously harm or cause serious death, correct?
Yes, Your Honor.
And not serious death, cause death, because any death is serious, correct?
Yes.
So therefore, you mean to say that government cannot stop that from happening?
Well, of course not, Your Honor.
Isn't that the intention there?
Well, that would be, Your Honor,
Yes.
an entire government is built on good intentions, but we really have to measure them on what the
Every
legislative
law is
process.
based upon an intention.
Yes, Your Honor.
Every law is an imagined future. Every law provides for a normative statement that says this should be how it is, correct?
Yes, Your Honor.
And no language does not clearly capture everything.
Yes, Your Honor.
Yes. And whatever the intentions were in this provision, isn't it the role of the judiciary to give a chance to the political department to be able to address the harm that they wish to address before we come out immediately on a theoretical point to actually to annul that provision?
Your Honor, my humble submission is that deference, judicial restraint ends where the Bill of Rights begins.
Yes, how does that violate the Bill of Rights? It says similar exercises of civil and political rights which are intended to cause death or serious physical harm to a person. If you want to read it, looking at government as evil or demonic, or with no intention at all except to do what is wrong, then you're probably right. Correct?
Yes, Your Honor.
Yes. But if you were a court of law like us, and you were trying to avoid imposing your own political convictions into an interpretation of a provision, but rather understanding that government really has to face certain kinds of terroristic acts. There was suicide bombing in Holo, correct?
Yes, Your Honor.
There were several, Marawi happened. And
Oh, yes,
in
sir.
my dissenting opinion, I called it terrorism. I did not call it rebellion. It happens, correct?
Yes, Your Honor.
In other countries, Facebook posts can cause a riot, as it did in Bangladesh or India. Correct?
Yes, Your Honor.
In the United
Washington.
States, post-truth committed riots, caused riots in its own capital. Correct?
Yes, Your Honor.
Yes. That is a reality which was not there in 1986, correct?
Yes, Your Honor.
Yes. And therefore, now government has to meet that challenge, correct?
Yes, Your Honor.
And the role of the judiciary now is what?
Your Honor, if there is a clear conflict between the means created by government to meet a new challenge vis-a-vis the Constitution's text, the role of the judiciary is to find what the Constitution means, because it is precisely here within these four walls
But a
that
clear,
this honorable court
a
decides.
clear conflict cannot be theoretical, meaning to say we read the constitutional provision, we read the legal provision, correct? The legal provision can bear, again, Spark, can bear an interpretation which can be legitimate. Shouldn't we wait for the actual case? Maybe the AITA case is the actual case.
Your Honor,
Maybe rural missionaries is the actual case. Maybe Gabriela is the actual case. Maybe this DND accord with the UP, I don't know, might be the actual case. But we have to see how government reacts. And the only thing that we see now is the Constitution, the law, and the implementing rules and regulations.
yes, Your Honor.
Yes. And should the court now weigh in when it has not been yet? Well, it's there. It is now law of the land. Should we not wait until there is a clear case? Perhaps there can be a petition filed on those that are red tagged. And perhaps the fact should be very clear. Goes to a regional trial court first so that the regional trial court can weigh in. By the way, counsel, can regional trial courts declare unconstitutionalities of provisions?
Yes, Your Honor.
Definitely, correct?
Yes, Your Honor.
And the advantage of regional trial courts, as opposed to the Supreme Court, is that the regional trial courts can receive evidence for it to be certain of the facts that provides the ambience, that provides the context for interpreting a provision. Is that not correct?
Yes, Your Honor.
So again, can you honestly tell us that we can step in with our power of judicial review considering all of this?
Yes, Your Honor.
Why?
Your Honor, there is already a clear conflict. There are two dimensions in this case. The civil liberties dimension, which can be met by a facial challenge even within the parameters of GeoSamar and Southern Hemisphere. And then there's a separation of powers dimension. Your Honors, the judiciary is called
I'm sorry,
the weakest
Counsel.
branch, Your Honor.
I have no idea what the dimensions you are. Can you again?
Yes, Your
explain
Honor.
this?
If you may
Yes.
allow me, I can elaborate. We filed our petition thinking of not just violation of the Bill of Rights, but also violation of the separation of powers under Section 29 of the ATA.
Again, Counsel, let me ask you. Congress is not concerned with the Bill of Rights.
It's concerned, of course, Your Honor.
President is not concerned about the Bill of Rights.
Oh, Your Honor, of course, our President is concerned with the Bill of Rights.
Really? You
Of
say
course.
that? Okay, now, the Army is not concerned about the Bill of Rights.
Of course, I have to presume that our
The
armed
police
forces
are. are
Yes, Your Honor.
concerned about the Bill of Rights.
Yes, Your Honor.
And interpreting any law, they will always have in mind the Bill of Rights, even if it's not written in the law, correct?
Yes, Your Honor.
So shouldn't we wait until they actually do an act that violates the Bill of Rights?
Your Honor, when the law itself is clearly against the Bill of Rights, Your Honor, then it is not for us to withhold really under expanded judicial review, Your Honor. That is our position. But we get, Your Honor, and we will certainly address the very incisive line of questioning, Your Honor, in our memorandum.
I don't think it's incisive because it's all in the genealogy of the court. This
Yes, Your
court,
Honor.
in a unanimous way, has already said that there must be a clear actual case. Yes, we have fears of any law. Yes, we have fears of any government. It's understandable. But to ask the Supreme Court to move in and use its powers without that standard would invite us to insert our own political perspective into how a law should be. I hope you understand that.
I understand completely, Your Honor, and I appreciate the line of questioning.
But because of the advice of the chief, it's 5:30. You can have 1 week to research on that point, and I will.
Yes, Your Honor.
We will call you again.
Yes, Your Honor.
We will continue Tuesday, this time at 2 o'clock in the afternoon. It will be all right. Yeah, we will start earlier. So that will be okay. So it's already 5:30. We will now adjourn the session today. Okay, let us start. Session is adjourned.
The associates that leave the session hall.